What is family-based immigration? Being together with family can be one of life's greatest priorities, especially when separated by international borders. In the United States, immigration laws reflect this value, making it possible for citizens and lawful permanent residents to bring their loved ones into the country through family-based immigration. The process can be complicated, particularly for those unfamiliar with English or legal paperwork. That's why many individuals turn to an immigration lawyer for help. Navigating legal procedures with the right attorney can mean the difference between delays and a smoother path toward reunion. The legal landscape of family immigration. Family-based immigration is anchored in U.S. immigration law, which permits citizens and lawful permanent residents to sponsor certain relatives for immigrant visas. These include immediate relatives, spouses, unmarried minor children, and parents of U.S. citizens, who benefit from an unlimited number of visas each year. Other relatives qualify under family preference categories, which are limited and subject to annual caps. To start the process, the sponsor must file Form I-130 with U.S. Citizenship and Immigration Services, USCIS, proving their relationship and financial ability to support the incoming family member. Additional steps include national visa center processing, document collection, and attending an interview. Immigration laws are exacting, which is why working with a lawyer can help reduce costly errors. What is family-based immigration? Family-based immigration enables a U.S. citizen or lawful permanent resident to petition for a close family member to live in the United States permanently. There are two principal categories: immediate relative visas and family preference visas. Immediate relatives are prioritized, and these visas are not subject to yearly limits. They include spouses, children under 21, and parents of U.S. citizens. Family preference visas, on the other hand, apply to other qualifying relationships such as siblings or married children, and are subject to annual caps, which often lead to backlogs and longer processing times. Sponsoring a family member starts with Form I-130 and includes financial commitments like submitting Form I-864 and affidavit of support to demonstrate the sponsor's ability to financially support the immigrant. If income requirements aren't met, a joint sponsor can step in. How the process works: the journey begins with a U.S. citizen or green card holder petitioning for a qualifying relative. For immediate relatives like a spouse or parent, the process tends to be faster due to the lack of numerical limits. These petitions, such as IR-1 or IR-5 visas, are prioritized and often processed in 5 to 9 months. In contrast, family preference visas face longer waits. These include categories like adult children or siblings, and may take years due to quota restrictions. Every application must go through medical exams and background checks. Approval of Form I-130 is followed by additional reviews, interviews, and visa issuance, depending on visa availability and case specifics. Because the immigration process can stretch over years, having an experienced attorney is invaluable. A qualified immigration attorney helps ensure paperwork is submitted correctly and provides insight into timelines and next steps. A law firm experienced in immigration law can also help track the progress of your application and represent your interests if complications arise. If you have questions about sponsoring a family member or need guidance through the immigration process, contact L Sanchez Law Office, PC at 646-701-7990. Visit us at 3763 83rd Street #1 meter, Jackson Heights, New York, 11372, United States.